Hello, I am a juror on the Christina Perry versus Ashford Hospital case in the matter of how Christina Perry's personal health information was used. Christina Perry is suing Ashford Hospital for the improper release of her health information protected under the privacy rule. This situation is complicated because Christina Perry is an employee at Ashford Hospital as well as a patient. Ashford Hospital distributed an operating room schedule to employees by email, which contained information about her upcoming surgery. In addition, the plaintiff's social security number, birth date, age, residence, insurance, payment information, former surgeries, medications, medical conditions, physicians, and therapists were also disclosed in the information. After looking at both sides of the case, in researching the HIPAA privacy rule and public health information, I would rule in favor of the plaintiff. Here is why. The privacy rule protects certain information that covered entities use and can disclose. This information is called the protected health information. This information is used to identify the individual by the information that is transmitted or maintained. The information must relate to the past, present, or future physical or mental or condition of the individual, provision of the health care to the individual, and the payment of the provision of health care to the individual. This information is only to be used to identify the individual, but in Christina Perry's case, Ashford Hospital used all past and present information in the email, even though she is an employee and her identity is already known. There is no reason for Ashford to disclose all information about their staff, especially if the information about the patient does not pertain to the surgery that will be performed. In addition to this, for covered entities who are using or disclosing the protected health information, the privacy rule sets requirements and standards to balance the patient's information. The entity must notify the individuals regarding their privacy rights and how the PHI is used or disclosed. They must adopt and implement internal privacy policies and procedures. They must train employees to understand these privacy policies and procedures as appropriate for their functions within the covered entity. They must designate individuals who are responsible for implementing privacy policies and procedures. They must establish privacy requirements and contracts with businesses associated that perform covered functions. They must have in place appropriate administrative, technical, and physical safeguards to protect the privacy of the health information. And finally, they must meet obligations with respect to the health consumers exercising their right under the privacy rule. As Christina Perry was a staff member as well as a patient, it is unclear if she was aware of the HIPAA privacy rules and had the proper training, which would be where and why the issue was overlooked, causing the confusion as to why certain information was used as well as the amount of information that was used. I do not believe that Ashford Hospital shared their staff members' information maliciously, but it did occur, which is why I ruled in the favor of the plaintiff. Hopefully, Ashford Hospital can learn from this mistake by ensuring all employees are fully aware of HIPAA. They take their employees' privacy into consideration by confirming their patients by using only the information that is needed to identify their employees. Thank you.